Hello. Today's case that we will discuss is Dr. Lawrence J. Ashker versus Aurora Medical Group, Inc. and Aurora Healthcare, Inc. The parties in this case are Dr. Lawrence J. Ashker, who is the plaintiff, respondent, and cross-appellant, and Aurora Medical Group, Inc. and Aurora Healthcare, Inc., which are the defendants, appellants, and cross-respondents. The facts in this case include Dr. Lawrence Ashker, who was a radiologist employed by Aurora Medical Group, Inc. Ashker and Aurora entered an employment contract that allowed Aurora to unilaterally terminate Ashker's employment. Ashker misdiagnosed a patient when he failed to spot a lesion on an X-ray image. After another physician brought the mistake to Ashker's attention, he attempted to delete the X-ray from the patient's medical record, even asking other employees to do it for him for cash. Due to this, Ashker was terminated. Aurora can terminate employment upon a material breach of the contract, provided that Aurora gave Ashker written notice specifying the breach and gave him 30 days to cure the breach. Termination can occur immediately upon the occurrence of any one of 7 specific events, none of which this event fell under. Termination for any reason, i.e., without cause, can occur with 90 days notice and 90 days pay. Aurora terminated Ashker's employment without following any of the 3 contractual options. Ashker's termination did not fall within the enumerated list of events that would allow Aurora to immediately terminate his employment. Aurora did not give Ashker 30 days to cure the breach. Aurora did not provide Ashker with 90 days of pay. The procedures for this case include that Dr. Lawrence J. Ashker sued Aurora Medical Group, Inc. and Aurora Healthcare, Inc. in 2012 through the circuit courts for 90 days of pay for breach of contract. The circuit court ruled in favor of Ashker under the without cause clause and ordered Aurora to pay Ashker for 90 days back pay. The court dismissed the claim of the alleged defamation related to false statements made by Aurora's employees against Ashker, citing that Ashker did not specify in his complaint which statements were false and his pleadings were not amended. The court also dismissed the claim that Aurora intentionally interfered with prospective contracts he had with potential employers. Ashker did not present any evidence that demonstrated this. Aurora appealed the court's order on Ashker's breach of contract claim. Ashker cross-appealed on the court's remaining rulings. The issues in this case include: did Aurora have the right to immediately terminate Ashker under the without cause provision due to the act being uncurable? Did Ashker violate any of the 7 specific events that would have resulted in immediate termination? Did Aurora comply with giving Ashker 30 days to cure the breach, which is in the contract? Did Ashker's termination fall under the termination for any reason clause? Did Aurora pay Ashker for 90 days of employment for terminating for any reason clause? Did Aurora's employees make false statements about Ashker which would allow him to sue for defamation? And did Aurora intentionally interfere with prospective contracts he had with potential employees by completing evaluations of him at others' request, the result of which had alleged had led at least one employee to let him go? Number 1, no. Aurora did not have the right to immediately terminate Ashker under the without cause provision due to the act being not curable. Number 2, no. Ashker did not violate any of the 7 specific events that would result in immediate termination. 3, no. Aurora did not comply with giving Ashker 30 days to cure the breach. Number 4, yes, Ashker's termination fell under the termination for any reason clause. Number 5, no. Aurora did not pay Ashker for 90 days of employment for exercising the any reason clause. Number 6, no. The general allegation in this complaint that Aurora made false statements does not meet the statutory requirement. And number 7, no. Ashker did not present any evidence that demonstrated he could meet the burden that Aurora knowingly provided false information in the reference. Reasoning behind the ruling includes that Aurora believes that it is entitled to terminate for an incurable material breach and the consequences of Aurora's decision not to provide the 30-day opportunity to cure in its for-cause termination letter. If Aurora had wanted to be able to terminate Ashker under the circumstances presented in the case, it could have negotiated such a term into the employment agreement. The contract limited Aurora's ability to immediately terminate Ashker to 7 specific events, none of which the parties alleged to have occurred. The contract further allowed Aurora to terminate Ashker for material breach or violation of its terms, provided that Aurora gave Ashker 30 days written notice and the opportunity to cure the breach, which Aurora did not do. The only remaining manner in which Aurora can unilaterally terminate Ashker's employment was by resorting to the catch-all without cause section of the employment agreement, which under it was obligated to provide 90 days notice or pay. Aurora did provide notice when it told Ashker its employment was being terminated. The court properly ordered Aurora to pay Ashker for 90 days of work, which he was due under the without cause provision of the employment agreement. The results of the case include: the Court of Appeals affirmed the Circuit Court's decision to require Aurora to pay Ashker for 90 days of employment after termination. As for Ashker's cross appeal, the Court of Appeals affirmed the Circuit Court's decision to dismiss Ashker's claim for defamation related to allegedly false statements made by its employees about Ashker. The Court of Appeals also affirmed the Circuit Court's decision to dismiss Ashker's claim that Aurora intentionally interfered with prospective contracts he had with potential employees by completing evaluations of him at others' request, the result of which he alleged had led at least one employer to let him go. The effect and importance of this case. Businesses need to include more specific events regarding immediate termination when terminating an employee, especially for those who violate the contract in an illegal manner or must abide by the terms in the contract. Aurora should have a termination clause that addresses the right to terminate an employee for acts or the attempt thereof that can be illegal and punishable, specifically for falsifying medical records. And last, parties could have avoided court by following the contract and paying Dr. Ashker for 90 days or allowing him to cure the breach. Aurora could not have clear actions that would qualify as immediate termination. Thank you.